There are a lot of assumptions that defendants and lawyers make about DUI cases in Georgia that are just, quite honestly, just mistaken. For example, a lot of people believe, both lawyers and defendants, that if it's the first DUI charge in your lifetime, you've never been in any trouble before, you get charged with a DUI, that your DUI is going to get reduced to reckless driving. That may be the case in some jurisdictions, but in the vast majority of jurisdictions in Georgia, that is not necessarily the case. So you don't just walk in and just automatically get a reduction to reckless driving or something else on a first lifetime DUI. You got to give some real reason why it is it should be done, or go forward to a trial to try those cases. The vast majority of my trials have been DUI trials where a person has never been charged with a DUI before in their life. So those people didn't walk in and just automatically get a reduction to reckless driving or something else. Another assumption that people make, and this is one that I think is really dangerous, it's an issue that I actually dealt with today, is that whenever you're arrested for DUI, and let's say, for example, that you refuse to submit to the test, and you file an appeal for that administrative suspension. So that means a separate process starts through the Office of State Administrative Hearings for the suspension of your license. And typically that will happen, that hearing will be set before the resolution of your criminal case. But there are some jurisdictions where a defendant goes in and just enters a guilty plea to the DUI charge. And as a result of that, they can't get a driver's license because they still got this administrative hearing hanging out there. They can't even get a limited permit during that period of time, even though they're actually eligible for it, because the administrative suspension for refusing to submit to the test is still hanging out there in limbo land. So they go into that hearing, and I see this pretty commonly with lawyers. They'll go in and say, "Judge, we've already pled guilty to the DUI charge, so why don't we just withdraw this?" And it is a big assumption that lawyers and defendants make that the officer is going to be agreeable to a withdrawal of the administrative license suspension because the defendant has already pled guilty. And consider what happens if the officer says, "No, I'm not going to." What happens then? So what happens then is that a defendant suffers a 12-month license suspension of their driver's license if they refuse to submit to the test, with no limited permit whatsoever. And it doesn't matter if the criminal court has said that you are eligible for a limited permit. If the officer won't withdraw the administrative suspension for refusing to submit to the test, even though it's a first lifetime DUI, you would not be eligible for a permit. And I say that because I had two cases in the last month where that was in fact the officer's position, was that no, I'm not going to withdraw it in either one of those cases. Even if your client agrees to plead guilty, I'm not going to. And I had to, in the first case, go forward with a hearing. Thank goodness. The officer did not know what he was doing. The administrative suspension was dismissed. He was really angry at my client for a lot of reasons, but did not know how to make out his administrative case. And in the second case, which is the reason why I did this video, was that this morning I went on a case where I was like, the officer obviously will withdraw this suspension. I had already gotten the case dismissed in the criminal court. So I showed the judge the final disposition. But I'll tell you, prior to showing the judge that disposition, it showed that the DUI had been dismissed. The officer had already said, "No, I'm not withdrawing the suspension." He didn't know what the law was. He didn't know that if you resolve a criminal case to something other than a DUI, then it automatically dismisses the administrative license suspension. But that would have been a huge mess if, in fact, the defendant had pled guilty already in the criminal case and for either one of those cases. And if you're in a position where an officer says, "No, I will not withdraw the administrative suspension," ideally what you want to happen is that then you go forward and just say, "I'm sorry, we're going to have to go to trial, have a hearing on this, on the administrative suspension, and we're also going to have to go forward on the trial on the actual DUI criminal case." Because if the officer is not willing to withdraw the suspension, there's no incentive whatsoever for you to agree to plead guilty. So um, I hope those are helpful, and I hope it sort of helps people avoid some of the pitfalls that I see people walk into just as a matter of timing, because all those problems could be resolved really easily just by virtue of resolving the administrative license suspension before you resolve the criminal case. clears up all those problems. So then you know what to do with your criminal case. Hope that's helpful. If you have any questions, feel free to drop me a line. Thank you so much.